Jackson, 60 WISC 2D 700, 211 and W2D 480, 487. The fee is the price. The regulation or control of the licensee is the real aim of the legislation. Are these licenses really used to fund legitimate government, or are they nothing more than a subtle introduction of police power into every facet of our lives? Have our enforcement agencies been diverted from crime prevention, perhaps through no fault of their own, instead now busying themselves as they check our papers to see that all are properly endorsed by the state? How much longer will it be before we are forced to get a license for our lawn mowers, or before our wives will need a license for her blender or mixer? They all have motors on them, and the state can always use the revenue police power. The confusion of the police power with the power of taxation usually arises in cases where the police power has affixed a penalty to a certain act, or where it requires licenses to be obtained and a certain sum be paid for certain occupations. The power used in the instant case cannot, however, be the power of taxation, since an attempt to levy a tax upon a right would be open to constitutional objection. See taxing power, infra. Each law relating to the use of police power must ask 3 questions. 1. Is there threatened danger? 2. Does a regulation involve a constitutional right? 3. Is this regulation reasonable? People v. Smith, 108 MST Rep. 715. Bouvier's Law Dictionary, 1914 ed., under police power. When applying these 3 questions to the statute in question, some very important issues emerge. First, is there a threatened danger in the individual using his automobile on the public highways, in the ordinary course of life and business? The answer is no. There is nothing inherently dangerous in the use of an automobile when it is carefully managed. Their guidance, speed, and noise are subject to a quick and easy control. Under a competent and considerate manager, it is as harmless on the road as a horse and buggy. It is the manner of managing the automobile, and that alone, which threatens the safety of the public. The ability to stop quickly and to respond quickly to guidance would seem to make the automobile one of the least dangerous conveyances. See Yale Law Journal, December, 1905. The automobile is not inherently dangerous. Cohens v. Meadow, 89 SE 876. Blair v. Broadmoor, 93 SE 532. To deprive all persons of the right to use the road in the ordinary course of life and business, because one might, in the future, become dangerous, would be a deprivation not only of the right to travel, but also the right to due process. See due process, infra. As it applies in the instant case, the language of rights and freedoms is clear. No person shall be deprived of life, liberty, or property without due process of law. As has been shown, the courts at all levels have firmly established an absolute right to travel. In the instant case, the state, by applying commercial statutes to all entities, natural and artificial persons alike, has deprived this free and natural person of the right of liberty, without cause and without due process of law. Therefore, it must be concluded that licensing cannot be required of free people because, taking on the restrictions of a license, requires the surrender of a right. The driver's license can be required of people who use the highways, for trade, commerce or hire. That is, if they earn their living on the road, and they use extraordinary machines on the roads. In other words, if you are not using the highways for profit, you cannot be required to have a driver license. Personal liberty consists of the power of locomotion, of changing situations, of removing one's person to whatever place one's inclination may direct, without imprisonment or restraint, unless by due process of law. Streets and highways are established and maintained for the purpose of travel and transportation by the public. Such travel may be for business or pleasure. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. Where rights secured by the Constitution are involved, there can be no rule-making or legislation that would abrogate them. The claim and exercise of a right cannot be converted into a crime. There can be no sanction or penalty imposed upon one because of this exercise of rights. It appears that we are no longer a nation governed by constitutional law, but have slowly and incrementally through mind control techniques a propaganda, become a nation controlled and dominated by bureaucratic regulation which operates under the shadowy color of law. Such could not happen if the public traveler who travels the public roadways in the usual conveyance of the day, that is, private automobile, for non-business, private purposes, were not coerced into entering a contract without full disclosure of the contract's terms being made at the time. Signing that contract without full knowledge of its terms, requires one to waive one's rights, and accept the full terms of a regulatory contract, with penalties and sanctions designed to police the actions and conduct of those who use the public roadways for business or profit. Do you honestly believe that those who sacrificed during 2 world wars, did so in order to give us the oppressive, invasive and unaccountable governments we now have? Are you tired of politicians promising one thing and delivering another? Had enough of heartless ignorant bureaucrats interpreting and enforcing statutes on a whim? I personally believe in the rule of law. I stand firmly against the abrogation of natural rights endowed to us by our Creator. At this time I respectfully demand that all records involving driving or operating privileges, all court records, all assignments, liabilities, and any warrants having my name on them be declared as invalid, nullified, and destroyed in this case, and the charge against me be dismissed with prejudice. In addition, since no notice is given to people applying for driver's licenses, that they have a perfect right to use the roads without any permission, and that they surrender valuable rights by taking on regulations of the system, the state has committed a massive construction fraud. This occurs when any person is told that they must have a license in order to use the public roads and highways. The license, being a legal contract under which the state is empowered with policing powers, is only valid when the licensee takes on the burdens of the contract and bargains away his or her rights knowingly, intentionally, and voluntarily. Few know that the driver's license is a contract without which the police are powerless to regulate the people's actions or activities. Few if any licensees intentionally surrender valuable rights. They are told that they must have the license. As we have seen, this is not the case. No one in their right mind voluntarily surrenders complete liberty and accepts in its place a set of regulations. The people never give up their liberties unless under some form of delusion. Isn't it time we took back control over our lives? On one final note, I believe an area of serious consideration for every police officer is to understand that the most important law in our land which he has taken an oath to protect, defend, and enforce, is not state laws and city or county ordinances, but the law that supersedes all other laws. If laws in a particular state or local community conflict with the supreme law of our nation, there is no question that the officer's duty is to uphold the Constitution. Every police officer should keep the following court ruling discussed earlier in mind before issuing citations concerning licensing, registration, and insurance. The claim and exercise of a constitutional right cannot be converted into a crime. Miller v. U.S. 230 F 486, 489. And as we have seen, traveling freely, going about one's daily activities, is the exercise of a most basic right.